A major, significant court ruling was made earlier this week in Waukesha County Court. You've probably heard about it. Judge Michael Maxwell ruled that the Kettle Moraine School District cannot encourage students to keep gender secrets from their parents at school. Staffers can't be complicit in this. This has become sort of a nationwide issue as more and more left-wing educators and activists are certain they know what's better for someone else's children than the parents do. And so when the parents of a 12-year-old student in the KM middle school discovered that their child's gender experimentation at school was going to be withheld from them, and it was a district policy not to inform the parents. The parents found the Alliance Defending Freedom and the Wisconsin Institute for Law and Liberty to take the case. They got a favorable ruling from Judge Maxwell and national news attention for it this weekend. Joining me to talk about this is Luke Berg. He's the deputy counsel for Will's litigation team and a former assistant AG. Good morning, sir. How are you?
Good morning. Thanks so much for having me on.
Thanks for being on. And I've tried to summarize the case for the audience. What did Judge Maxwell rule, and why is this such an important decision?
Yeah, Judge Maxwell ruled in our favor on summary judgment, which is just the process to get a final ruling from the judge when there's no factual dispute in the case, and there wasn't here. So it's a final ruling from the judge that the district's policy to treat children as if they're the opposite sex at school without parental consent violates parents' rights to raise their kids. So in this case, our client's daughter, as you indicated, in the fall of 2021, she was 12 at the time, had a mental health crisis. It spiraled into, for a time, believing she was a boy. She wanted to transition at school, but her parents said, no, we're not saying no, never, but we want to take a more cautious approach. We want you to process what you're feeling, understand what you're going through before you make this major change. And they communicated that to the school, and the school basically said, sorry, too bad. If you send her here, we're going to call her whatever she wants. And so the parents, as any parent I think would do in that situation, immediately pulled her from the school, pulled her from all the environments, social media, a healthcare environment where she was being, quote unquote, affirmed that she was really a boy. And within only a few weeks of being pulled from those environments, she realized, actually, Mom, you're right. This, in her words, she said, affirmative care really messed me up. This confused me further to have adults around me saying, you're really a boy. So I just confirmed that the parents understand their daughter better than anyone else.
Hear, hear. Judge Maxwell made it clear that those teachers and other adults have control over the curriculum in the school buildings, but when it comes to medical and healthcare decisions, that clearly falls to the parents. Sort of sad we have to have a court tell us this, but he made it clear they must be notified about gender dysphoria or experimentation occurring at school. Is that an accurate statement?
That's a very accurate summary. A lot of the defense of school districts is to say, well, we have power over curriculum, and obviously this is not a curriculum decision.
Right.
So again, it shouldn't require a court district to say that. A court to say that. It seems like such an obvious point, but that's where we are right now. There are numerous school districts across the country who have policies like this. There's litigation happening nationwide, and this is the first win on behalf of parents on a claim against one of these policies. So it's a big win. We're hoping it will set a precedent and be the beginning of a wave of wins that will hopefully begin to change the tide on this.
We're talking with Luke Berg of the Wisconsin Institute of Law and Liberty. The judge also wrote that, quote, the school district could not administer medicine to a student without parental consent. That's true. The school district could not require or allow a student to participate in school a sport without parental consent. That's true. Likewise, the school district cannot change the pronoun of a student without parental consent without impinging on the fundamental liberty interest of the parents. There's a reason that children are sent to school and that the adults in their lives make a lot of the important decisions for them, isn't there? And the parents and educators are supposed to be working together on this mission to raise these children. So these policies that are meant to sort of deceive parents really just run against what has been the grand tradition of raising children for eons.
Right. Yes. I mean, the assumption is when you send your children to school that if anything significant comes up at school, you're going to immediately get a call home, right? If your child gets into a fight on the playground and gets punched in the eye, you expect a call from the parents. And anybody who sends their child to school knows you get parental consent forms constantly. And yet school districts have carved out this one issue, this major controversial and life-changing decision, and said, not only do parents not get to be involved in the decision, we will actively hide it from them in some circumstances.
Right.
And that is stunning.
And moreover, I want to emphasize this was also a pronoun case because the decision barred CAM staffers from referring to students by a different name or set of pronouns without express parental permission. And I understand the facts of the case. When challenged over this, the middle school staffers refused to follow the parents' wishes and refer to this girl by her given name and pronouns that were female. That's a willful display against the parents' wishes, and they seem to be going out of their way to be antagonizing. How is this important just as a pronoun case?
Well, it matters a lot because addressing a child as if they're the opposite sex actually can have long-term psychological implications. So I think a lot of these policies are motivated by the mistaken belief that, what's the big deal? We're just respecting this student's, asserted identity. But kids who are struggling with their gender identity, with gender dysphoria, often have deep psychological issues. There can be a lot of other stuff going on. And so mental professionals recommend against an immediate transition and a careful professional evaluation to make sure that to figure out what exactly is going on with the child. And if you put them into an environment where all the adults around them are, quote unquote, affirming that they are really the opposite sex, it can reinforce what ends up being a false belief and cause them to persist in that belief longer than they otherwise would have. And there's actually a pretty robust body of research showing that the vast majority of kids who struggle with this ultimately find comfort with their body and stop wanting to transition. But there's some initial research that suggests that the likelihood of that changes dramatically if they transition. So it actually has a big psychological impact, and that's why it's so important for parents to be involved.
There's also this double life issue. I believe, didn't you have doctors testify that living that double life, at home one thing, secret life at school, it's inherently psychologically unhealthy? I mean, that's a message the entire country and Western world, I think, needs to hear, because the secretive nonsense is starting to spread everywhere.
Yeah, I mean, right. Like, the idea that schools would be inviting students to live different lives at school and at home is terrifying. I mean, it's basically like they're treating school as if it's Las Vegas, right? Everybody here knows what your name and identity is, but what happens here stays here.
Yeah, what happens in school stays in school. So this ruling let's get back to the legal elements of this. This ruling is a major win for parental rights. And given that the makeup of the Kettle Moraine School Board has now changed, and the head of it, as I understand it, says most board members agree with that parents need to be notified. They're going to change their policy. Does this mean that there's no party to appeal here, right? I mean, this isn't part of some case that's going to end up setting precedent statewide then, huh?
Yeah, that's right. The district would have to appeal, and I've seen the same comments from one of the school board members. So it looks like they're probably not going to appeal, but instead change the policy, and that's a good thing. Mm-hmm. So the ruling is not technically going to be binding on any district other than the Kettle Moraine School District. But in any case on this topic, and on any topic, judges often look to what other courts have done under similar facts. And so this is going to be a case that will be cited and looked at by other judges in every case on this subject, and there are many. I don't know if you have seen or your listeners have seen, but there's a group that is collecting a list of school districts that have policies like this, and so far they've documented 1,000 across the country. And there are, by my count, at least 20 different lawsuits on the subject. So this is a nationwide issue, and we expect that there's going to be a lot more litigation before it's ultimately resolved, and we hope that this decision is the beginning of a wave of wins.
Well, and to that point, I know that Will, as a mission statement, we're talking with Luke Berg of the Wisconsin Institute of Law and Liberty. I know as a mission statement, you've been promising to take more of these cases and try to get the legal ball rolling on a trend that has parents and adults with common sense, taking back their schools and protecting their kids. So are there other cases that you're working on, or are they just going to develop over time?
Yeah, we have another case against the Eau Claire School District that's currently going. That one was in federal court, same basic policy. We lost at the trial court level on standing, not on the merits. So a lot of the losses in these cases are on ancillary issues and not on the merits. There are very few judges that are willing to say, yeah, it's totally fine for a school to hide this decision from parents. So that case is up on appeal to the Seventh Circuit currently. We had another one against the Madison School District that we litigated for 3.5 years. We tried every procedural mechanism we could think of to get a court to rule on the merits, and despite 3.5 years of litigation, we did not get a decision from any court on the merits. And during that time, all of the 14 parents who sued left the school district, so that case got mooted.
What a shock in Dane County.
Next steps there.
In Dane County, you couldn't get that going. And I know you're not a lawyer. I know you're a lawyer. You're not a doctor. But it's worth noting, I think, for listeners, that when this girl's parents checked in, there are a couple of different sets of parents that were actually involved in the KM situation. But when this 12-year-old girl's parents checked her into a mental health facility, the staff there never really dug into her gender confusion. The parents, anyway, characterize it as they labeled this as gender dysphoria and started treating her like a boy and urged parents to do the same. Well, 2 years later, that girl is happier and mentally healthier and is living as a girl, as her biological sex now matches her gender identity. And we've allowed a lucrative cottage industry to pop up around this gender confusion fad or movement, whatever you want to call it. And it seems to be sort of screwing up far more of our children than it's helping. And that's just my editorial comment, but I thought I would make it and just ask you if you have anything else to add before we wrap this up.
Yeah, that is an extremely important point for parents who are listening to hear. If you ever have a child who struggles with this, you need to be very careful about who you send them to in the medical industry, because there are a lot in the medical industry who will not question at all, will not dig in at all, but just immediately affirm that your child is the opposite sex. The healthcare provider that our clients sent their daughter to even told their daughter, the sooner you transition, the better, and your mother is going to be your worst enemy.
Wow.
So it just, as you can imagine, that sparked a lot of conflict in their family. And we're happy to say now they have a very strong relationship, but
good. And it's clear this
sending your child to that.
I didn't mean to step on you. It's clear that this mother isn't some sort of kook. This isn't sort of some, ultra religious nut. The mother, just in comments, has, I think, been very measured. She said it's a very scary place for a parent to be in when you are faced with this, because you don't want to make a mistake. We never had to deal with this as kids. She said trying to figure out the best course of action almost paralyzes you because you don't want to make the right choice. And she said when, she was hesitant to give blanket advice to other parents that might be dealing with this. But one of her quotes is, you should certainly stand up to your school district. You should try to get groups of parents together that are willing to stand up to the district if they have a policy like this. I think that's great advice. Luke Berg, we've decided, by the way, you have a great John Hausmian name, Luke Berg.
I appreciate that.
Are you old enough to know who John Hausman is?
I wish I were.
Oh, okay. I didn't think so. He's an actor. He's a very established and distinguished actor who would pronounce things that way. Luke Berg with the legal team, which is doing so much important work in protecting our rights here in Wisconsin and more nationally. Thanks for being on. I appreciate it.
Thanks so much for having me on.